In a victory for the Constitution, Judge John Brooms in the United States v. Morgan case courageously upheld the Second Amendment. He rightfully dismissed charges against an individual possessing a machine gun and a Glock pistol modified with a switch. His ruling echoes the true meaning of the Second Amendment. It stands against government overreach. Judge Brooms correctly recognized that the Second Amendment protects the right of individuals to own firearms. This right is not limited to antiquated muskets. The Second Amendment safeguards the right to possess bearable arms. This includes modern firearms. This decision is a beacon of hope for all Americans who cherish their constitutional rights. It stands against a tide of unconstitutional gun control measures. It reaffirms the fundamental right of individuals to defend themselves, their families, and their liberty. The Second Amendment is not a relic of the past. It is a cornerstone of American freedom. It guarantees the right of individuals to keep and bear arms. This right is essential to a free society. It ensures that the people retain the ability to defend themselves against tyranny. The Founding Fathers understood the dangers of an oppressive government. They had just fought a revolution to secure their freedom. The Second Amendment was designed to prevent the government from disarming the people. It ensures that the people would always have the means to resist tyranny. This right is absolute. The government has no constitutional power to regulate firearms. Any restriction on this right is unconstitutional. The government cannot simply ban any weapon it deems too dangerous. To do so would be to gut the Second Amendment of its meaning. The Founding Fathers were clear in their intent. They wanted a well-armed citizenry. They believed that a well-armed citizenry was essential to deter tyranny. They knew that a disarmed populace is vulnerable to oppression. The historical context of the Second Amendment is crucial. The Founding Fathers had experienced firsthand the dangers of a tyrannical government. They were determined to ensure that the American people would never be subjected to such tyranny again. The Second Amendment was not intended solely for militias. It was intended for all citizens. The right to keep and bear arms is an individual right, not a collective right. It is a right that belongs to every law-abiding American. The Second Amendment protects the right to keep and bear arms. The term arms encompasses all items that can be used for defense or offense, including modern military firearms. To argue otherwise is to ignore the plain meaning of the text. The Founding Fathers knew firearm technology would progress. Repeating firearms had been in use for over a century before the Revolutionary War. They used broad language in the Second Amendment to ensure that it would remain relevant over time. The right to keep and bear arms must be understood in the context of modern technology. To limit the Second Amendment to the weapons that existed in the 18th century would be absurd. It would render the amendment meaningless. The Founding Fathers were not concerned only with single-shot muskets. Take the example of the Belton rifle, a repeating rifle that could shoot 15 rounds in 20 seconds. It was presented to the Continental Congress in 1777. They were concerned with ensuring that the people had the means to defend themselves against any threat. Section 5. The 1986 Machine Gun Ban and the National Firearms Act of 1934. Both are unconstitutional infringements. They are both a blatant violation of the Second Amendment and the Constitution. These laws prohibit law-abiding citizens from owning a category of firearms. In the case of the National Firearms Act, it only allows some weapon types and some accessories with permission after paying an extra tax. They infringe on your constitutional rights. These bans are not rooted in the historical tradition of the Second Amendment. The government has failed to demonstrate that machine guns are not in common use for lawful purposes. There are currently 740,000 registered machine guns in private hands in America. The Second Amendment protects the right to keep and bear arms that are in common use. This includes machine guns. The 1986 ban is a prime example of government overreach. It is an infringement on a fundamental right. It sets a dangerous precedent for further erosion of our Second Amendment rights. Section 6, Echoes of Heller, reaffirming the right to bear arms. The Supreme Court has recognized the Second Amendment as an individual right. In the landmark case of District of Columbia versus Heller in 2008, the court struck down a handgun ban in Washington, D.C. The court held that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes, such as self-defense within the home. The Heller decision was a major victory for gun rights advocates. It reaffirmed the individual nature of the Second Amendment. It struck down a restrictive gun control law that violated the Constitution. The Heller decision should serve as a guidepost for lower courts as they grapple with Second Amendment cases. The right to keep and bear arms is not a second-class right. It is a fundamental right that is essential to a free society. The Heller decision recognized this truth, and it should not be ignored. Section 7, the Bruen decision, reinforcing historical tradition. The Supreme Court further clarified the Second Amendment scope in New York State Rifle and Pistol Association, Inc. v. Bruen, in 2022. The court invalidated New York's restrictive concealed carry permitting scheme. It held that laws restricting the right to bear arms must be consistent with the nation's historical tradition of gun regulation. The Bruen decision built upon the foundation laid by Heller. It provided a clear framework for evaluating the constitutionality of gun control laws. The court emphasized that the Second Amendment's text and history are paramount in any analysis of gun regulations. The Bruen decision is a significant victory for originalism. It recognizes that the Constitution's meaning is fixed at the time of its ratification. The court's emphasis on historical tradition ensures that the Second Amendment will continue to protect the right to keep and bear arms as understood by the Founding Fathers. Section 8. Refuting the critics. Addressing misconceptions and fears. Critics of the Morgan decision and the broader movement for Second Amendment rights often rely on emotional appeals and misinformation. They claim that allowing individuals to own modern firearms, including machine guns, will lead to increased violence and endanger public safety. These arguments are unfounded and lack any empirical basis. The vast majority of gun owners are law-abiding citizens who use their firearms responsibly. They use them for self-defense, hunting, and sport shooting. They pose no threat to public safety. In fact, they often serve as a deterrent to crime. The focus should not be on restricting the rights of law-abiding citizens. It should be on addressing the root causes of crime, such as poverty, lack of education, and mental health issues. Blaming inanimate objects for the actions of criminals is a simplistic and ineffective approach to a complex problem. Section 9. The dangers of judicial activism, protecting original intent. Opponents of the Morgan decision advocate for a dangerous approach to constitutional interpretation, judicial activism. They want judges to impose their own policy preferences instead of upholding the original meaning of the Constitution. This approach undermines the rule of law and threatens our system of government. Judges should not be in the business of legislating from the bench. They should interpret the Constitution according to its original meaning. This means understanding the text and historical context of the Second Amendment as it was understood by the Founding Fathers and the American people at the time of its ratification. Judicial activism is a threat to our republic. It allows unelected judges to overturn the will of the people as expressed through their elected representatives. It undermines the democratic process. It erodes public trust in our institutions. Section 10. Safeguarding our rights, the importance of the Second Amendment. The Second Amendment is more than just a constitutional provision. It is a bulwark against tyranny. It is a guarantee of individual liberty. It is a fundamental right that deserves unwavering protection. The right to keep and bear arms is essential for self-defense. It is essential for deterring crime. It is essential for safeguarding our freedom. When citizens are disarmed, they are at the mercy of criminals and tyrannical governments. We must remain vigilant in defending the Second Amendment from those who seek to undermine it. Our freedom depends on it. The future of our republic depends on it. Section 11. A call to action upholding the Constitution. The Morgan decision is a step in the right direction. It is a victory for the Constitution. It is a victory for freedom. But the fight to protect our Second Amendment rights is far from over. We must continue to elect officials who will uphold the Constitution. We must continue to challenge unconstitutional gun control laws in court. We must continue to educate our fellow citizens about the importance of the Second Amendment. The Second Amendment is under constant attack. We cannot afford to be complacent. The time to act is now. Let us stand together and defend our right to keep and bear arms. Let us preserve this fundamental right for ourselves and for generations to come.